Good morning, everyone. My name is Justice Henry. I use she, her pronouns, and this is the April 1st, 2024 sitting of the Appeals Court. To my right, we have Justice Hershfang, who also uses she, her pronouns, and to my left, we have Justice Smyth, who uses he, him pronouns. I think everybody's familiar with the rules, but just in case, we have 15 minutes per side, for better, for worse. There is no rebuttal in the Appeals Court. We are a hot bench, in my experience, and you should consider that a good thing because it tells you what we're concerned about and helps you help us understand your case. And sometimes you'll see us like looking at our devices. That's because we try to be fairly paperless here, and so we have notes and your briefs and your record on our devices, and that helps us. So we're paying attention to you in your case. It's just that, you know, we're trying to keep up with the technology. So with that said, I'll call our first case this morning, which is 2023-P1058, James Barros and another versus the Nantucket Select Board and others. Counsel.
Good morning, Your Honors. May it please the Court. My name is David Hadass. I represent James Barros and Rose Marie Samuels, two black residents of Nantucket, who appeared at a select board meeting intent on giving comments during the public comment period, primarily about a racist act that occurred on Nantucket where the African Meeting House was graffitied. I'll start with Ms. Samuels. During Ms. Samuels' comments, she was...
So could I pause you there? Just, it sometimes helps us to either just get the basic lay of the land or right size the case. So I want to understand, at the time of the interruptions here, was there a time limit on how long the speakers could speak to the board?
I don't believe that there were rules regarding a particular number of minutes or anything like that. We recognize that time, place restrictions are reasonable.
Okay. And does it matter to us for our analysis that the board changed its policies about comments after these events?
No. So the board did change its rules, I believe, in response to the BARAN decision by the SJC. And so we have regarded the old rules as being a moot issue. But it's the town officials' actions and behaviors during the meeting that is the subject of our litigation. Ms. Samuels' comments were responded to with loud and scornful interruptions, primarily by the town manager. And Mr. Barros, before he even spoke, was called out by the chief of police in public, labeled a spreader of rumors, and someone not to be trusted before he even had a chance to speak.
So someone could argue actually that the chief was sort of goading him to speak. In other words, the chief was saying he's right here and he hasn't been speaking, so, you know, let's hear from him.
Well, that might be fine, but to say that he's been spreading rumors and to essentially convey the message to the board and anyone else in the room that his word is not to be trusted, that's the problem that we have with the chief's comments.
What was it about the chief's comments that he wasn't to be trusted? What were the words the chief spoke?
Well, I believe he said that he's been spreading rumors and comments to that effect. It was, I don't remember if there were, what other precise words there were, but the message was clear that this person has been spreading rumors and don't believe them.
And without at all diminishing how upsetting and painful that must have been to Mr. Barros, what is the constitutional right of Mr. Barros's that was being violated by that comment, if we take them as you say we should?
So his speech, which of course he has free speech rights, as we all do, was diminished by the chief's intimidation before he even spoke. And so while Mr. Barros was able to, in the end, deliver the comments that he wanted to deliver, they were essentially under a cloud. And so we're not here to say, like what happened in BARAN, that speech was completely cut off. It's the quality of the speech that's at issue. They were able to get the words out, but interruptions, being yelled at, being told that the comments were inappropriate or improper, and in the case of Mr. Barros, being intimidated before he even was able to make those comments. So it diminishes the quality and the persuasiveness of their speech.
So do you have a case, I agree with you that BARAN, excuse me, Mr. Barros, the names are so similar.
Yes.
I agree that BARAN doesn't speak directly to this factual situation because the speaker in BARAN just was not allowed to continue speaking. What is your best case for the proposition that someone who is allowed to continue speaking but with interruptions has suffered a First Amendment constriction of their speech?
Yes. The most instructive case, even though it wasn't technically a free speech case, is Batchelder, if I'm saying that correctly. In Batchelder, that's the case where the individual running for office is handing out political literature in a shopping center and is told by a private security guard that that's against the rules, he can't do it.
And he stops.
And he stops.
So I agree with you that it's not a free speech case. It's sort of, at best, a collateral MCRA case. But it is also not a case in which the plaintiff's speech or his, First Amendment protected activity was not stopped by an official. I got so lost in my own sentence, but do you know where I was going? Is there, and I'll take a federal case, if there's a First Amendment case that's closer on point. Did you run into anything similar to this, factually?
Well, not exactly. This is, I would suggest, what Batchelder, where it left off, and in fact it invited future courts to pick up where it left off, because it focused on Article 9, and it said we don't need to get to Article 16, and if you look at that case, they essentially invite a future court to pick it up with Article 16, and I would suggest that the rights to free speech under Article 16 are just as important as and consequential as the rights under Article 9.
So if I could follow up on that, this is a two-part question. Where should we, or where does the law already draw the line in terms of how much interruption or constraint or back and forth is permissible, and what is the source for your answer?
Well, as I said, I believe our survey of the cases didn't come up with something factually exactly on point. But the pitch we're making here is that the speech, when town officials interrupt you, tell you you're being inappropriate, et cetera, storm out of the room, creating sort of a chaotic atmosphere. How valuable is your speech? When one shows up at a select board meeting intent on delivering comments during public comment period, your hope is that if you deliver your comments well, that hopefully you're persuasive to members of the board, hopefully you're persuasive to members of the community within earshot. And the question that this case presents is, did those town officials allow these individuals to make that type of speech that could possibly be persuasive, could possibly be compelling? The answer is no. It was, they were met with derision, And so anyone in that room, I think, would agree that their ability to speak, their ability to persuade was greatly diminished.
You seem to be positing an entitlement that is greater than the one that I'm familiar with in either Article 16 or the First Amendment, which is a right to be listened to and heard. While I think it would be wonderful if we all had such a right, I don't see the law as providing more than a right to be listened to make your point. If you look, for example, at the SJC decision in Commonwealth versus Bigelow, which is different in a number of ways, it's a criminal case, but it had to do with a resident of a town who sent a number of letters, threatening letters to an elected official, and was prosecuted under the threat statute. And the SJC said, no, those aren't threats, they're protected political speech. And the protected political speech in that case was pretty unfriendly and certainly not at all persuasive, but none of that was required. It was simply required that he be able to speak his mind to the elected official. I think if we claw back to that level, your case becomes more challenging, and that's what I'm hoping to hear from you, because I want you to put your best case forward. I guess maybe if we could shift to the other plaintiff, because the two are differently situated with respect to the board's interactions with them. What is the strongest case for why Ms. Samuel's First Amendment Article 16 rights were violated here?
Well, again, I would point to Batchelder. I think you have a case there where a security guard told the person to stop. They stopped and went away. There was no yelling or anything of that sort. And I think if we replace and what the court found persuasive in that case is that someone with authority, a uniformed officer, essentially prevented the person from continuing to exercise their rights.
Counsel, could I just have you pause for a moment, because I don't think it's supposed to be flashing like that. I'm sorry to interrupt you.
No, that's all right.
Just for whatever record matters, we were at 3 minutes and 38 seconds when she asked you to pause.
Thank you.
I believe it is okay to continue. It is simply a light issue that we've been having with this,
Okay, great. Okay, thank you.
but recording is still going fine.
I have a feeling we're going to run long anyway, so I'm not worried about your...
So what Batchelder teaches us is that you have someone with authority, tells the person to stop what they're doing, and that's sufficient for a violation. In our case, we have clearly people with authority, and telling the speakers to stop. And so the question is, they persisted, they persevered, they were able to get. We can't say that they were able to get the speech that they intended to make out, but they were able to give several minutes of comments. And so the town will make much of that. But again, what is the value of that speech given the atmosphere that was created, given the objections from the town officials?
So is it an undisputed fact that the town manager is not a member of the board?
She's not a member of the board. That's correct. But if you look at the video, she's up there with the board members. It's to a resident, it would be indistinguishable, that person from the board members. And whether you're a member of the board or a town manager, either one is a position of pretty high authority within town government.
Do the plaintiffs have a right that she stay and listen? I know she made a very noisy, unpleasant withdrawal, but, we have to think not just of this case, but of other cases too. So does she have to stay and listen?
Well, the town manager is not required to be at the board, to be at the meeting, so So we accept that, but the chaotic atmosphere that she created is what's more important. And so if I could, that reminds me, if I could circle back to Justice Hershfang's comments. No, you don't have a right to be listened to in a sense that the person you're speaking to can sort of roll their eyes and tune out, and that's not a violation. But when there's loud interruptions, that diminishes the person's ability to speak and ability to persuade, and so that's the important thing.
So
Yes.
one thing that happened here was that the town manager advised Ms. Samuels that if she had a charge to bring against the town manager, she could do it during a properly posted agenda item. And so in that space where she's trying to direct her apparently to a future time, is that an attempt to silence her? Do we parse it to say, well, she silenced her at that meeting, or do we look at the whole picture there?
Well, that was one of a number of comments that purported to silence her. This wasn't a quote-unquote charge that Ms. Samuels intended to bring. This was something that, this was a comment that she made in the context of larger comments. And what BARAN teaches us, among other things, is that town officials cannot be so thin-skinned as to react that way to a comment like that. In BARAN, the speaker compared the board chairman to Hitler, and the SJC didn't find that any justification to cut off speech. So given that the standards here are so favorable to the plaintiffs, this must be judged under strict scrutiny. The Civil Rights Act is to be liberally construed. The summary judgment standard is that no reasonable jury could find for the plaintiffs. Given the undisputed facts, it's all on video, so there's not much dispute here as to what happened. And given these favorable standards, we believe that the judge improperly cut this off and should have allowed this case to go to trial so that Mr. Barros and Ms. Samuels could have presented their case to a jury of their peers.
I have a few questions. I just want to ask you a few questions about your burden, sir. Under the second count, under the Civil Rights Act count, you'd agree the judge stated the correct law on the burden, the plaintiff's burden, that they're attempting to enjoy or exercise a constitutional right, that there was attempted interference with, and that attempted interference were a threat, a coercion, or intimidation.
Correct, yes.
What was the attempted threat, coercion, intimidation, or what was it? Was it coercion, threat, intimidation? In my follow-up question on count one, determining under the Article 16 claim, is it the same framework, the same burden? The same sort of test? I mean, they were trying to exercise a right, and there was an attempt to interfere with it. Because it seems like there's a lot of focus on, well, they had their say, so there was no interference with their right. But if there's an attempt to coerce or intimidate or threaten, first, can you tell me what your best case is for that? And second, whether that same standard is applicable or relevant to the count one?
Yeah, so coercion is the easiest to satisfy. The courts have said threats involve some sort of threat of physical restraint. So Ms. Samuels, when she was speaking, because of all the interruptions and objections, she was coerced to curtail her speech. And in the case of Mr. Barros, it was more intimidation. The chief of police standing up, pointing them out, et cetera.
And these are live streamed as well, these meetings?
Your Honor, I know generally they are these days, but I can't say for certain if this one was.
But for him to be I withdraw that. You may continue if you have
So-
anything further.
So, yeah, the standard.
We just need to restrict to questions at this point because you're far out of time.
So just one question about the last thing you said before. Justice Smith asked you his questions. You said it's all on video, there's not really a dispute of facts. We do also have, as part of the Rule 9A package, an affidavit from each of your clients and sworn deposition testimony from each of your clients. I take it that you are not, that your statement about the video is not a statement that we should ignore the testimony.
No, not at all. Certainly, the testimony goes to the impact that what you see on the video had on the speakers. There's also a little part of it that's off video, that's sort of filled in through testimony.
From Ms. Samuels.
Yes. But to answer your question, Justice Smith, we believe the standards would be the same under Article 16 and under the MCRA. Well, except for the coercion, intimidation, and threat, there could be a declaratory judgment of a violation of Article 16 without those elements. Thank you.
So, Ron, I
Yes.
apologize,
sorry,
you're not off the hot seat yet. So you say in your brief that there's an obvious difference between speaking without interruption and speaking while being bombarded with frequent and dismissive interruptions. But in the scenario where the speaker perseveres and makes all the points they wanted to make, which I think is where we are for both of your clients, what is the difference for free speech purposes?
I'm sorry, what is the?
What is the difference? You say it's obvious, but I just want to make sure
Yeah.
we
Yeah.
know what it is. I mean, obviously, we all prefer to be uninterrupted.
Well, certainly, but there's different types of interruptions. Like the interruptions that you've made today are perfectly acceptable, and I welcome them. But being loudly yelled at and derided is quite a different thing. And I think any speaker who's had any experience trying to persuade, I'm trying my best right now, knows the difference between those types of interruptions and the type of interruptions that you see at the select board meeting.
All right. And then finally, at least from me, just so we're very focused, is it correct that Ms. Samuel's claims are really focused only on the behavior of the town manager and not any other interruptions?
Yes, it's the town manager.
Okay.
It's the town manager. Initially, well, I'll leave it at that. It's just the town manager.
Thank you.
Thank you.
All right, with that, we will hear from Councilor Ecker.
May it please the court, Deborah Ecker, for the town of Nantucket, the town manager Elizabeth Gibson, and the former police chief William Pittman. This all arises from this select board meeting on March 11th, 2020. To answer your question, at the time there was no time limit on how long a member of the public can speak during the public comment period. Ms. Samuels got up and she began to speak. During her speech, she made a statement that the town manager was untruthful. The town manager is not a member of the select board and has no authority to shut that meeting down.
Right, but his response is, to a member of the public, she looks like she's got a lot of authority, and nobody's shutting her up.
Absolutely true, she does, but not in this context to shut it down. She, if you look at the video, goes through the chair. It is the chair then who controls the meeting. Ms. Gibson admittedly became upset, but it's Ms. Gibson who left the meeting. It's exactly what you want someone to do who becomes upset. And it's Ms. Samuels. This was a short period of time during which the town manager became upset. She has a colloquy. She says if you want to bring a charge forward, you can do so at a future time, which was what was in the policy at the time. She sits, she turns to another member of the select board. She says to him, and you can sort of hear this on the video, can I leave? Or I think I should leave. And she walks out.
It wasn't a graceful exit.
Wasn't a graceful exit, but she doesn't say anything as she walks out.
But I thought she said something on the way out.
Well, so it's not on the video, and so the Superior Court judge, even in the summary judgment, despite the evidence, and this is a summary judgment, not a motion to dismiss like in the BARAN case, took those facts as true, even though it wasn't on the video, and said, even if that's true, she left, Ms. Samuels was able to get up and continued speaking. In fact, she was sitting actually for a while and she spoke, and the chair of the select board said, you know, we really need to move on. Ms. Samuels continues to speak and says, look, if you're going to continue to speak, come up to the microphone. Again, inviting her to come up. Ms. Samuels comes up to the microphone and she finishes her speech. She then, I'm sorry.
Thanks. And, you know, we appreciate this, but you can be confident that we have all watched the movie at least once. Do you agree that both plaintiffs' speech was protected speech?
I do, yes.
Okay. And then, obviously, as you've mentioned, this was decided on summary judgment. So in reviewing the record, we will take the undisputed facts as undisputed, and it does not seem there's a factual dispute here. Part of the undisputed factual record, then, is that each of these town members felt, I don't want to use the word threatened because that seems like a legal conclusion, but felt that his and her right to speak was being impeded and felt that they were being called out in some way by the various members, either the town manager or the police chief, depending on which claim and which plaintiff you're looking at. If taking those facts as true, why isn't that a jury issue?
Well, I would disagree with you a bit, Your Honor. So I don't take those facts as true. They're like allegations in a complaint. How were you threatened, right? I suffered emotional distress. You need to prove that with a factual record on summary judgment. So I don't take as true the fact that they were threatened, felt threatened, because we have what's on the videotape, and the videotape shows that, yes, the town manager became upset, but then she leaves. I don't hear anything that the other disruptions by those members of the select board who spoke out supporting Ms. Samuels, right, abridge their rights to speak. You know, we want to hear, we haven't connected these two incidents. She had spoken about a bike accident that her son had been in. And so I don't take those as true for purposes of the summary judgment mentioned, how they felt. But let's say you do take that as true. For purposes of summary judgment, their speech wasn't abridged. You have to get to that piece first. They were allowed to speak. They were allowed to conclude their speech. In fact, Ms. Samuels spoke for almost 10 minutes.
So is your position, is the town's and your other client's position that if someone is not, and I'm going to use an extreme case, so don't think I'm talking about this case, but if efforts to quiet someone down are unsuccessful because that person has the fortitude to just keep talking against all the odds, that there can be no Article 16 violation?
So there are no cases actually on attempted interference that I've been able to find in this and other cases that I've had. However, based on these facts, these aren't, for instance, a select board chair saying, I'm going to call the police, I'm going to have you escorted out if you're not quiet, as in the Natick School Committee case. It's not an instance where I'm going to shut down this meeting by the chair. Instead, all you have, and I'll get to Mr. Barros in a minute, all you have is the town manager who she becomes upset, you have a charge, bring it to me. You know, she does say at one point, and I know if you've watched it, you know, this has to stop, but the chair who is controlling this meeting allows us all to continue. Town manager walks out, the meeting continues. For Mr. Barros, this wasn't in a vacuum. So Ms. Samuels asks some questions. You know, good deed doesn't go unpunished, right? The chief, who didn't have to get up and probably wasn't the proper forum for him to do so, not on the agenda, gets up to speak. And he says, this isn't the proper forum. Not the proper forum, but he's going to answer Ms. Samuels' questions. And one of those questions is, who is the individual who says they have information who hasn't provided it to the police? Now, Mr. Barros had already been before the board, undisputed, in prior meetings. He had submitted a letter to the board about—
Let me interrupt you. We're familiar with those facts. Could it not be considered an attempt to coerce with a police chief who may or may not have a firearm on his side, calling this forum an inquisition. Is that what he called it, an inquisition?
Yes, he did call it an inquisition.
And would that not be a little bit coercive maybe to a witness who was providing a statement? And after that statement was made, might they maybe change what they were going to say? If the police chief of that town was saying this is an unfair inquisition, and might that be perceived as an attempt to coerce someone to not continue to speak?
None in this factual context at all,
I know.
Your Honor. Because what he was saying is this forum is improper for this dialogue, right? And so he still gets up to answer the questions. And so it's Mr. Barros, as I understand my brother saying, who would have felt, would have changed his speech. But this dialogue had gone on at a prior meeting. In fact, Mr. Barros had submitted this letter. The police chief had submitted another letter in response to Mr. Barros's letter saying this is all the police department has done to try to get information from Mr. Barros that he said he had. So
Why was it not a proper forum for citizens to find out what the town knew, what was going on in this investigation?
sure. So under the open meeting law, the topic has to be posted on a proper agenda. And so public comment, there shouldn't be. And we always instruct the public officials not to have a back and forth with those in the audience. It's not a time for them to deliberate or dispute, get into one of these arguments with a resident. Most policies now do have a time limit, 3 minutes, get up, let them speak, and they move on their way. Because under the open meeting law, if they were going to discuss that topic, it should have been posted.
So on the prior occasions when it had been discussed by white and by black witnesses, it had been posted?
My understanding is it had, Your Honor. It wasn't that it came up. Some came up in public comment, but I don't believe there was a dialogue. There was some posting about the status of the investigation. I think that may have been on some of the prior agendas, but nothing about, again, answering questions. So the chief wasn't wrong. He probably shouldn't have gotten up, but he did get up to answer the questions. And then he sat down. He didn't say, he didn't react to Ms. Samuels calling him untruthful, gave his piece, reminded everyone that this has been turned over to the state police. He sits down, Mr. Barros gets up, speaks. The only interruption in his speech was the chair reminding him that this had been turned over to the state police, and any information that anybody had should go to the state police instead.
Did you get your question answered?
I don't remember my question.
Okay, all right. I know the policy at that time said that public comment was limited to matters within the purview of the Board of Selectmen. Given that the case had been transferred to the state police, was this matter in the purview of the Board of Selectmen?
It's our position it wasn't. The judge below didn't agree with me, but it's our position that it wasn't within the position of the Board of Selectmen. Now, the judge below rightfully pointed out that the Select Board had talked about it at prior meetings, but
Who had talked about it at prior meetings?
the Select Board had talked
Oh,
about it
okay.
at prior
All right.
meetings, is what the judge below pointed out. But it had been our position below that this wasn't within the purview, the jurisdiction of the Select Board.
You mentioned that the town manager had apologized to Ms. Samuels both publicly and privately. Is that relevant to our decision are we just focused on the events of the date in question, March 11th, 2020?
So she apologized and the others. I do believe it's relevant for if you find that there's abridgment of right and get to the civil rights, whether there's threats, intimidation, or coercion, because even coercion under the standard requires more than just statements. It's actions to effectuate what you've said. And so after this meeting, couple member of the Select Board, and this is in the record, reached out to Ms. Samuels, and the town manager did apologize. She was rude, no question, right? But every intemperate statement does not violate someone's civil rights. If that were the case, a lot of these public meetings would lead to lawsuits, a plethora of lawsuits. So that's how we believe that that's relevant, Your Honor.
So he argues that the police chief basically essentially said bad things about Barros, that he was a rumor monger, and that, so what's your response to that?
Well, that's not, there's nothing in the video where he says that. What he does is answer Ms. Samuel's question. There had been an article in the newspaper in which the chief had said, there's someone, who says they have information who hasn't provided it to us. And so that's what the police chief pointed out. That man is sitting, or gentleman, I forget which word he used, is sitting here today, and he points to Mr. Barros. There's nothing that he's a rumor monger, although now that we've had discovery, we've now learned that he didn't have any information. But that's not what was said at the meeting at the time by the police chief. And even then, the judge below, even though, and I know you've watched the video, you don't see a gun. The chief in his deposition couldn't remember if there was a gun or not, if he wore it.
But don't we take it as true that, for purposes of summary judgment, that there was a gun? Because even if we can't see it in the video, if he says he saw a gun, we have to take that as true, right?
Well, I would argue that the judge didn't, because you can't see it in the video, but yes, even if you take it as true, particularly since we had argued below, and I still think it's the case, every time a police officer comes to a meeting in uniform with a gun, you can't take that as threatening. Not a lot, but there are meetings when police officers, and particularly police chiefs, come in uniform and speak, and just because they speak or perhaps say something that you don't like doesn't mean they're threatening you just because they're standing there in uniform with their gun. And in this case, you saw he was wearing a fleece, and it's not visible, doesn't point, gesture in any sort of way.
So I have watched the video, but I don't recall at this moment. Did the chief refer to Mr. Barros by name?
He did not. He said he points.
I think he said not to name names, but the person who did this, and then gestured toward Mr. Barros.
Yes, exactly.
Does that
is what he
matter?
said. I'm sorry?
Does it matter that he didn't name names but pointed to him?
Yeah, I mean, it's a small community. This had been discussed before. Everyone knew who Mr. Barros was. Everyone knew, at least for the select board members who were listening, about these letters and the back and forth. This was not the first time these individuals had come up to speak before the select board.
It's apparent from the record that by March 11th of 2020, Chief Pittman and the members of the police force in Nantucket knew or had been given information by someone as the name of at least one of the people, and I think he was the only one ever identified, who had done the racist graffitiing. To what extent is that relevant to our consideration of what the chief said at the meeting, which was directly to the contrary?
Well, it's not relevant, but I caution. Plaintiffs put that in their brief, and I know they have a civil judgment against this individual who took the fifth. He was named as a defendant in this case, and who didn't respond to the summary judgment. In civil cases, you can use that against the defendant. To this day, and this again was turned over to the state police, the DA, no one has been charged with this crime because you have to prove it beyond a reasonable doubt.
But this is a civil case.
This is a civil case, yes. But what the police chief said, he wouldn't have said anything different, honestly, at the hearing. He's not going to sit there and reveal aspects of the investigation, which is one reason he thought it was an improper inquisition, right?
But there's a lot of territory between not revealing details and affirmatively saying, we have no idea.
But at that point, they didn't, right? Because, yes, we have that individual who had been rumored. There were a number of individuals who were rumored. In this case, Ms. Samuels and Mr. Barros kept saying it was the town manager's son or some high school student with no support. Police chief is not going to get up there and say, well, we think X, Y, and Z did it. And again, the individual who is named as a defendant here has never been charged with the crime, presumably because the state police couldn't prove it beyond, or the district attorney, beyond a reasonable doubt.
So if the advice, and I'm not asking you to get into any privileged information, but if the advice to these town board members is just sit there and take it and let them have their say, right? But we don't do anything in this case. Like if we were to say what happened here is not actionable, how do we get the board members to sit there and let them just speak?
Under Article 16 and First Amendment, they don't have to just sit there. They can have a dialogue back and forth, but if you don't want to have a lawsuit, right, and have the court sit and parse what is, an infringement of your First Amendment or Article 16 rights, then don't say anything. Just time it, let them speak, and move along. Just because that, and I'm not saying that was the advice here to this client, but in general is advice that's given, doesn't mean that if they make comments or give some information during the meeting, that it violates that individual's right to free speech.
So his whole argument is that it's just obvious that if you're just constantly interrupted, and there were certainly a number of interruptions here, that changes the quality of the speech and it's a violation of speech. Why is he wrong about that?
Well, there's no case law that discusses your right not to be interrupted, right? There's a dialogue back and forth here. You might not like the tone or the manner in which the town manager said comments and then left, but there's no, and I found no case law, none, that talks about your right for your speech not to be interrupted, even if, there's some yelling going on or some unpleasantness in the exchange of dialogue before the board.
Do you believe that strict scrutiny is a proper standard for the count one?
I'm sorry?
Strict scrutiny, do you believe that's the proper standard for count one?
Well, the strict scrutiny is the proper standard. If your speech is abridged, why is it abridged? You apply strict scrutiny. Here, it's our position the speech wasn't abridged. So you don't have to get into which type of forum applies. But yes, in BARAN, the SJC did find that it was strict scrutiny.
In BARAN, there's a facial challenge, which we don't have here. Do you believe that's a distinction of note?
Yes, it is.
And how should the court then analyze the content as different from the facial challenge? For instance, if there were no policy, but it was just a challenge on the content,
So first, you have
for the
to
potential content abridgment.
you have to find abridgment, and then if you find that their speech is abridged, if their free speech right, they didn't have their right to free speech, then under strict scrutiny, was there a compelling reason, right, for, but here, there was no abridgment of speech, so you don't even have to get there.
Thank you both, very well argued.
Your Honors.
The matter is submitted and we'll take it under advisement. Our second case today is 2023-P-0786, Susan Lynn Lavender Barron versus William N. Ford Sr. and others. I think we're starting with Attorney Grossman, is that?
Good morning, Your Honors. Josh Grossman for the appellants. The decision of the trial court should be reversed for 4 reasons. First, there is no subject matter jurisdiction for the DJ claim it tried because Lavender, the plaintiff, lacks standing as her alleged injury is not within the zone of interests protected by the revival statute 156B, section 108. Second, Ford and Sterling were interested parties under 108, and it was legal error to rule otherwise. Third, there was no fraudulent misrepresentation in the application for revival, as the statement at issue was opinion rather than fact, and was not material, if it was fact, to the Secretary of the Commonwealth's decision-making on whether to revive. Finally, it was prejudicial error to exclude evidence of the liens that Lavender placed on charitable land and her plan to sell that land and pocket the proceeds because both were relevant to the nature of the injury she claimed and thus to standing.
So,
Go ahead.
So on your first argument that the plaintiff lacks standing, what's the standard of review for findings on her standing?
The standard of review for findings on her standing, would be clear error. We submit, I guess it sort of works like this. You look to what injury does she allege in her complaint. And here, the injury she alleges is personal and pecuniary. It's financial. She said she had an interest in this land secured by these liens and a right to come in and sell that land and pocket $1.4 million of proceeds. The defendant in this case should have been permitted to put on evidence, certainly should have been permitted to put those liens themselves into evidence to cast some light on, well, what is the nature of this injury? What is this claim? If you look at the liens themselves, it becomes apparent that they were the amounts were unilaterally determined by one director in the dark. That changes the nature of her interest from, well, I'm a director and I've got business with this company and I expect to get paid someday, to just a straight self-dealing transaction with respect to charitable assets.
Well, she also says, though, and she says you don't challenge, that she basically lost her mission, she lost her job, she lost the foundation, she lost her home, and that package, probably singly and in combination, provided her with standing. Why is she wrong about that?
She is wrong on that because it's more than just, good luck finding in Chapter 156B or Chapter 180 some interest that says, or some statute that says, a director has a personal property right in the charity that they perform fiduciary duties for.
I don't think that's what she's saying, though. I think she's saying this was literally my life mission. This is what I did with my life. At the end of my life, that's what my obituary is going to say.
She may well have been saying that, Your Honor, but the claim she brought challenged executive action. It challenged administrative action by the Secretary of the Commonwealth in a setting where the legislature provided and gave no indication in the statutory scheme that it ever contemplated permitting people to appeal to Superior Court and complain about its grant of an application for revival, flipping the lights back on a defunct corporation, a dissolved corporation. There is nothing in Section 108 that suggests we want these cases brought into Superior Court. She needed to prove that she had an interest that was within the factors of Fore River.
Well, before you get into the
contemplated by
injury-
the chapters. Sorry, Your Honor.
I'm sorry, did you?
I did. I apologize, stepping on your question.
My question is a more limited question of standing under Chadsey Barker, I think it is, where the judge found she was a director, and a director has standing to challenge or to revive a corporation. You'd agree?
I would agree. I would agree with part of that. I would agree with that. I'm sorry if you didn't finish.
If she has standing, based on the judge's findings, she was a director to revive the corporation, then are you saying she doesn't have standing to challenge its survival?
Yes, Your Honor. It's exactly what we're saying. There is no question, and the Superior Court cited one case that said, look, an officer of a company that hasn't been making its corporate filings and got administratively dissolved, sure, of course that officer, or and I'm sure a director, would be an interested party. That's what this case holds. It doesn't speak to standing. It speaks to, yeah, you would qualify as an interested party to come and seek revival. No question about it. But that is not the same thing as somebody having legal standing under the DJ Act, which requires a basis in standing. If the statute you're complaining about doesn't provide it, to ask that the Superior Court review the grant of revival and undo it, and basically throw the lights back off on this corporation and move it back into a state of dissolution. That is, or a state of dormancy. There is a different statutory provision that is intended to be exclusive for charitable corporations. It's in 180, Section 11A, that says if you want to dissolve a charity that still has assets, first, you know, it's a two-step process.
That's a voluntary dissolution, though, correct?
Absolutely, a
We're not
voluntary
talking about a
dissolution.
voluntary dissolution here.
Well, she came to court asking that an act of revival, or, you know, administrative decision reviving a company be reversed. I mean, I don't know why that's not voluntary. I mean, she came and she asked for it. Voluntary in that sense, Your Honor.
So,
I'm sorry.
so the plaintiff argues that you did not make the argument about her seeking to make personal use of this property and to pocket the money. So I just need a record site where you did make that argument below.
So we absolutely supply that record site in at least our reply brief, and likely our principal brief. It was preserved at Record Appendix 3, page 156, 157, 158. And the dialogue there was in reference to trial counsel's effort to an offer of proof, saying, I'd like to offer these liens into evidence. The copy of the liens are at, which were marked for identification as N down below. They're at Record Appendix 3, pages 569 through 577.
But counsel, the entire purpose of that argument was counsel wanted the judge to review these claims substantively. And the judge said, I don't know if I have jurisdiction, but I'm going to limit the first part of the trial to these three other issues: standing and interest in the merger and the revival. So they never raised it as part of a standing, or can you point to somewhere where they raised it as part of a standing as opposed to wanting to litigate whether the lien, the interest against the property were valid?
Your Honor, I would submit that the issues were one and the same. Whether, let's think about what we're talking about here. The factual question of whether or not she was actually owed money, whether these liens were actually valid, whether these liens were developed with any kind of third-party scrutiny, board or judicial scrutiny, that speaks to the nature of her alleged injury. Because what's her injury? She lost control of a charitable asset. She was living on this charitable asset rent-free, and she says right in her complaint, she wanted to sell it and satisfy these liens and pocket the proceeds. So if those liens were not genuine, if the money was not really owed, it goes right to standing. It's the nature of the interest she complained about. What else are we trying
I have a lot of
in a
trouble
case on
with
standing?
that argument. I have to say, it seems like a sort of sidestep, unclean hands argument. And I don't know how you can consider or why we should consider unclean hands in the context of standing. So I want to push you a little bit by offering a hypothetical that is different. Let's say it was a different charitable organization that had been run for many years by a different person and fell into disuse. You know, same things happen with respect to the legal status of the charitable corporation. But this imaginary person who was running it had a heart of gold, you know, only good hopes, had taken nothing from the charity, in fact, had dedicated the last 2 decades of her life to running the charity for its charitable purpose, would that person have standing to challenge its revival by a third party?
So we have a director who's got a heart of gold and who is, in your hypothetical, the director hasn't filed a complaint saying she intends to sell charitable assets and is entitled to some of the proceeds.
That's right.
Right? We just have a director who wants to challenge the secretary's act of reviving a corporation. No, there's no standing there. We look to the 4 river factors because the only claim they brought was under declaratory judgment, and that statute doesn't provide an independent basis for standing when you are challenging an administrative action of the government. Otherwise, every director could bring a DJ claim about every administrative act carried out by the Secretary of the Commonwealth.
Well, I
And
mean,
it's
I don't
just
think you need
beyond
to
what
go
was
that far,
contemplated.
right? I mean, every administrative act, we're not talking about some ministerial task here. We're talking about the existence of the charity. Does it exist or not?
And the legislature prescribed no means to complain about a decision by the Secretary saying, lights on, it exists, let's get to the next subject, let's get to the substance.
So with my heart of gold theoretical imaginary director, that person's just stuck because there's no explicit right to go to court? They have no recourse?
They have no recourse on that issue. What happens next, they have recourse on. They could show up to a meeting if they believe that, whatever the next substantive action that occurred was improper or unlawful, they may well have an interest there. But this decision creates real problems if affirmed. I mean, the trial court determined that everything that happened after revival was no good because the revival was no good. The revival, for the reasons laid out in our brief, there was no standing to get into it in Superior Court. The legislature just never intended that. And my clients were clearly interested parties. Parties who have hostile intentions with respect to the company they are waking up out of a slumber. Pretty much every instance they are found to be, I don't have any instance where they're not found to be interested, but we have interested parties have been found where they are creditors who want to sue, where they want to sue to enforce indemnity rights, where they want to undo a merger that was agreed to by both companies. And someone comes in after the fact and says, I want to undo this. None of those are waking them up for some, consented to, approved deal. People revive
So you haven't cited
for
to any
lots of
cases
reasons.
in which there's no apparent interest, such as this case, where there's no existing claim or relationship. The Harpoot case, there was a clear relationship between the parties, as they'd been prior, I believe, board members. But let's just grant the interest. There's a lot of focus on the interest. But even if Ford and the parties had an interest, is that controlling, considering what the judge found about the misrepresentations that supported the revival and the merger? I mean, let's grant standing. Let's grant not just standing, but an interest. Is not the revival and the merger, could not the judge have found them void based on the facts that he found, again, of the misrepresentations?
Very briefly, he could not have with respect to the misrepresentation. I'll come back to that in a moment. There is certainly a case that we have cited. I believe the title is Kennedy. It's an appeals court decision that involved basically the purchaser of a television whose daughters were injured in a fire, who wanted to revive the company that had since been dissolved, that sold it, to sue under a products liability theory. Entirely hostile, entirely strangers. You don't have to, know one another to revive. In terms of why were the statements in the application not fraudulent. They were opinion and not fact, and even if they were fact, they were not material. They did not relate to any criteria of the enabling statute 108 or to its regulation or to any question posed on the application. So assuming for arguendo that they were false, they were not material and could not have resulted in a fraud, and the Harpoot case from 1937 addressed that exact issue.
Thank you very much.
Thank you for your time.
We'll hear from Councilor Zerner.
Good morning. May it please the court, Bridget Zerner for Susan Lavender Barron. The Ford parties come to this court and ask this court to ignore the factual findings of the trial court and ignore the case law that supports those findings and the conclusions of law made by the trial court. And to do that for parties who came to this Commonwealth from New Mexico to lie to our secretary in order to steal a nonprofit and take its assets. I know the court is familiar with my papers, so if there are specific areas that the court would like to talk
Why
about.
don't we pick up where he just left off, which is that these statements that the judge found to be false, he says, well, they're not material, so we shouldn't be concerned about them. What do you say to that?
They are clearly material as the court, because it goes directly to a requirement for your revival application, which is that you need to be an interested party. And Ford and his cohorts were trying to establish themselves as interested parties by making the false statements that the Ann Wigmore Foundation was defunct, that no one was there who had authority to operate the nonprofit, and that he looked everywhere to try and find someone with authority and couldn't find it. So therefore, he should be recognized as an interested party with a nonprofit who has the goal to merge this nonprofit in Massachusetts with his in New Mexico.
So I take it you say it's particularly material because not only did he not look everywhere, he didn't go to the one obvious place and maybe a couple of other board members.
Exactly. In addition to making a false statement by omission, by not revealing that Susan Lavender was there, the trial court made findings that not only was she a director, but that she had made it clear to Ford she was a director, that she represented to Ford, and he well understood that she was selling the property as a director on behalf of the Ann Wigmore Foundation and not selling it as her own personal property, and that he was aware that New Mexico Secretary of State filings reflected her as an officer. And so he omitted all of that in addition to the actual misrepresentations that he made.
So you argue at page 27 of your brief that the evidence established that Lavender did not want to keep the foundation defunct, but wanted to properly revive it herself as the true director. I didn't see, and you have some record sites, but I actually didn't see that proposition in your record sites. So could you talk me through how those record sites, and this was page 27 of your brief, how those record sites support that?
Yes, Your Honor, and I would also add there are the court should also look to the trial court's actual factual findings.
That's fine, we could start there.
Okay, and that is, and I'm with one moment so I can see the exact findings you have there. First off, the court found on page, and I'm looking, I know there's multiple copies of the trial court's opinion, so I'm looking at RA 3 and 5. .584, the trial court found that Susan Lavender didn't know the corporate charter was revoked, and that goes to the fact that then she's not trying to keep it defunct because she didn't even know at the time it had been revoked. The court also found on that same page that she was selling the property on behalf of Ann Wigmore Foundation to use the proceeds to move the foundation and its operations to Virginia. And as I had just mentioned, that she made clear she was selling it on behalf of the Ann Wigmore Foundation to Ford in her discussions that she was moving the operations. She didn't want, one, she didn't even know that the corporate status had been revoked, but she wasn't trying to keep it that way. When she realized it, then what I also cite to is Trial Exhibit 17, which is at RA 1, 439 to 441. That's her fax to the Mass Commonwealth. When she discovered that Ford had done this, she writes to the Commonwealth and says, this is a fraud, I'm the true director, we'll do it. And I believe her language is something like, we will reapply when we deem it appropriate. And she's not a lawyer. She was very upset at the time, as all the emails in the record show. But that she wanted, then the other evidence is as well, at RA 3, 129 to 30, and page 140, was her testimony at trial that not only had she sent the fax to Massachusetts trying to undo this, so that she went to the New Mexico Secretary of State as well to try and do filings there, because she was trying to address the improper status to revive it there. She wanted to be the one to revive it when she realized that it had been revoked and the consequences of that.
Right, but he's saying, well, she wanted to revive it because whatever our intents are, she's a scoundrel too.
Right, and actually what he's
What do we
saying
do with
is,
that?
two parts. First, he's not saying she wanted to revive it. Their argument throughout their papers, which caused such confusion in our response, was that she's trying to keep it dissolved and wants it dissolved. And that was not in the record at all. She wanted to keep the Ann Wigmore Foundation mission going. And when she realized this is what needed to be done, she had to fight forward to be able to get back, to have the Commonwealth recognize her, to allow her to revive it. And to your next part of your question is, she's a scoundrel too. Well, that goes to the point, the judge acknowledges if she's a bad director, because even if she's a bad director, taking assets from a nonprofit, that doesn't give standing or give Ford the right to come into the Commonwealth and lie to the secretary to take that nonprofit from her. That needed to be addressed otherwise if she was improperly, executing her duties as the true director of the Ann Wigmore Foundation. And I don't want to, is there any other questions from the panel on any of the other issues?
Well, the interested party definition or understanding, it's a very broad term. I believe Justice Talwani spoke to kind of the tautology. Just because you show an interest doesn't mean you're an interested party. But the judge posed a bit of a hypothetical as well, or said if the Ford party had come in and wanted to make an arm's length transaction for the land, they may have been an interested party. Did you agree with that, or would you, where do you believe the contours of the interested party lie?
So you're referring to, in the trial court's comment, the hypothetical about having a transaction. I mean, just on those limited facts, I would agree with that. Of course, if you're actually in a lawsuit, there might be more to it than that. But the interested party definitely shows that, one, LAVENDAR, as a director and officer, is an interested party. If you're a member of the organization, you're affiliated with it. Or that you're a creditor or an adverse party, like in Russellbox, I believe, where you need the company to be in good standing to pursue your claims against it. So all of those, whether or not a transaction, I think possibly, but I think it might need more facts. I think the contours go that you actually have a connection with the property, an identifiable interest as an affiliated party or as an association that's clear, like a creditor or a party suing the company, not Ford. Ford had no idea what the Ann Wigmore Foundation was, and the factual findings we're using, because they've made clear in their reply brief they're not challenging the factual findings, was that he just wanted to get that 21-acre property for his own uses without paying for it.
Right, but what do we do with a situation where, for whatever reason, there is a nonprofit that holds some valuable property and everyone is just gone for whatever reason? They died off or they, had other problems. And so now you have this 21 acres being held in the name of this company and nobody's around. Should we really not let somebody who wants to buy the property come in and acquire the property?
That's potential if there really was no one around, which is not the facts here. But I think there's also,
But if we rule the way you want, it sounds like we would have to say, no, that person couldn't come in and revive the nonprofit and you put the property to use.
Well, here in Massachusetts, there's the other statute that allows one to petition the court to transfer nonprofit assets from one nonprofit to the other. So that would have been available, court, and that is going to the court to do that. And Mr. Ford could have done that. And then he would have had to establish before the court why it would be appropriate for the nonprofit and Wigmore Foundation. He'd have to prove that it was defunct, and then they should be transferred under that statute. So that remedy is available without making the rulings that Ford wants regarding the revival statute here. And I think my only last point would be is if the court considers it, I think when the court looks at the factual record, now that, as I said, our papers, we spent the time to address factual findings because it wasn't clear to us from the way the brief was written that they were not challenging the factual findings, including because they kept making false statements about the facts, like that Lavendar was trying to force the Ann Wigmore Foundation to be dissolved so that she could take all its assets. So considering that, considering the case law here, that they repeatedly misstate the factual record, that they misstate the law under Russelbach's and Harput, and they did also use this. The Ford parties, we have a pending suit in New Mexico, and the Ford parties, when counsel in New Mexico on behalf of Lavendar went to file a motion there to seek relief and get to vacate the declaratory judgment that had previously been entered by the New Mexico court based on the secretary's revival before we had the trial. They have then most recently filed papers saying the New Mexico court should not act because we have a pending appeal. The judgment by Judge Salinger is not final. So I think considering all that this may be a case for sanctions, considering the record here and the arguments made.
I had a question on standing. Technically, when Lavendar filed her complaint, the revival had been allowed, the companies had been merged. She didn't seek to dissolve, or you're arguing standing under her position as director, she'd have standing to revive. That's under Barker, or Chadzey Barker, Barker Chadzey, correct? But she's not seeking to revive.
In the case, we can seek to revive because that was something that does go back to the secretary. So what we were seeking is to void the revival by Ford so she could then go back to the secretary, which she has now done. So Susan Lavendar has revived it with the secretary.
But you're saying standing to revive thus grants you or confers standing to act as you just described.
Here, standing to challenge the revival by Ford because there was clear evidence of an injury within the scope of the statute. The fact that these strangers came and took the nonprofit away from the proper director.
Okay, and that's a little broader than I think maybe I interpreted your brief. But under the injury plus the Enos factors, there's been a lot on the nature of her injury. But as a director who was unbeknownst to her, there's been a revival of the nonprofit. Does that alone amount to injury?
Yes, I think it does, but it's shown by the cases, like Harput, where you had a group that was an organization with members, and there were certain members that had acted for a merger, and then another group of those members wanted to challenge it. And the way that case reads, that the fact that they were a member at the time, that gave them standing to challenge.
My final question is on the standing question also. There was a lot of discussion about the liens in New Mexico. In your position, correct me if I'm wrong, is the judge decided here, Judge Salinger, to not try those substantive matters, again, the interest in the land. But he did, over your objection, allow deposition testimony as to the existence of the lien, but trial court just failed to introduce that evidence. Is that an accurate summary of what occurred?
Yes, you said trial counsel failed to introduce it, yes.
And you believe they have waived their challenge to standing based on that aspect?
Yes.
So what did you mean when you said she'd gone back to the Secretary of State and revived it?
And revived it?
Yes, I mean, well, because it was already revived, so.
And this is outside the record. I mean, since we got the ruling from
Okay,
Judge Salinger.
all right, okay, that's fine. We can
Yeah.
Stop there. Do you have any other questions? Okay. Thank you very much. You have, actually, you have a minute and whatever, so if you have any other remarks, you may use your time.
I won't take any more of the court's time. Thank you all.
Much. We'll hear the next case, and then we'll take our mid-morning break. Case 2023-P-0999, Robert H. Sarvis versus Leslie M. Bassett and another. And we're going to hear from Robert Sarvis first. Party Sarvis should address the court.
Good morning, Your Honors. This is a breach of contract case where the defendants defaulted on February 1st by failing to plead or defend within the 20-day period. The rules required entry of default and default judgment per my motion for some certain amount of $65,000 stated in the complaint. And the Superior Court should have struck the defendant's 12B motion of February 10th. The Superior Court also erred when it granted defendant's motion to dismiss on jurisdiction. For over 16 months, the defendants voluntarily contracted with me in Massachusetts for consulting services that they requested. I performed the services in Massachusetts and sent them to them in Georgia, where they used them in their litigation. But they refused to pay for the services they received, and their actions caused me additional damages. They claim Massachusetts does not have jurisdiction to address my claims. That is incorrect and inconsistent with Massachusetts law, and the order must be vacated. Regarding the defendant's default, the reporter's notes describe default under Rule 55A as definitional, ministerial, and automatic. Moore's federal practice agrees, as did this court in Hermanson, First Circuit in Indigo America, Second Circuit in
I think part of
Bricklayers.
the issue is when you're looking outside of Massachusetts, we have a different, and some would say good, and other people would say very irritating rule under the Rule 9A, which is we file entire motion packages. So you don't just file the motion to dismiss in court, you actually serve it on the other side. They write an opposition, they serve it on you. Sometimes there's a reply, you put the whole package together, and in fact, there's a whole nother rule, Rule 9E, that says if you want to prevent the entry of a default, you can just submit a notice that there is a motion to dismiss hanging around out there, but you know, most clerks are very busy and they don't just enter a default right away. So you can't rely on the federal cases because we have a different rule here.
I understand that, Your Honor. But in this particular case, the rule says by affidavit or otherwise. And in this particular case, the clerk knew they hadn't filed on the 31st, per my
Why did the
affidavit.
clerk knew that?
Pardon?
Why did the clerk know that?
She talked to the defendant, and they said that they weren't able to file it. So she knew on the 31st. So on the 1st, she knew that they hadn't, and she should have entered it. She was required to
So
enter it.
then, I mean, we also just generally have a principle that we prefer litigation to be resolved on the merits, and so by that conversation, the clerk knew that there was a defendant out there that was trying to do the right thing, and so generally speaking, we let that play out, and we don't just ding people out for technical reasons. So
Well,
what was wrong with,
Except that's what the rule says.
but that is the difference too between a default and a default judgment, which I'll grant you is very confusing to non-lawyers, and in fact is very confusing to lawyers.
It's not confusing to me. I understand what default is.
Right, but then what happens though is that because the person had been in touch with the clerk, that if a default enters, the person just turns around and makes a motion to remove the default, and oftentimes that's granted, and so they just let it play out.
I understand that, but they didn't make that motion. And this is a ministerial function, which is mandatory. When they have not answered, and the clerk knows it, that should have been entered. Now, that's what the rule says. Now, I understand, but the clerk doesn't have an authority. The court does. The defendants could have gone to the court and asked for more time, but they didn't. And they didn't file a motion 55C when they were in default. And so that is what the rules say. Now, you can say, well, we have ways that we don't abide by those rules. Okay, then when do you have to answer? That would eviscerate Rule 12A1. Why give us 20 days? Just file an answer any old time. That can't be the rules. These are the rules. And the reason you have a default is because the rules say they've got to be a penalty for you not answering timely. They didn't. Therefore, their motion can't be filed as a responsive pleading on the 10th.
So what's your record citation for the idea that the clerk had actually spoken with one of these folks?
I put that in my affidavit. I discussed it.
How do you know the clerk spoke to this person?
Because she told me. And I put that in my affidavit because I filed I filed a motion to strike because there hadn't been any entry on the docket. And I hadn't heard anything. And I served it on the 7th. It didn't get filed until later, but that's a different matter. But I filed that for a motion for entry of default and of default judgment on the 7th. Now, she returned that to me because she said that they had filed this responsive pleading on the 10th. And I say that responsive pleading is barred by their default, and it is also waived under Orange Theater because it's wasn't filed within the 20 days.
I'd like to ask you about your other argument about the jurisdiction. And I just want to clear up one factual thing. It appeared to me from the record that there was not a written contract
There is
between
not.
you. Okay. But you do include in the record, and I take it these documents are uncontested, various drafts of legal papers that you maintain you drafted and then the defendant filed with little or no change. Is that right?
That's correct.
And does the record contain evidence of any agreement between you and the defendant about how you were to be compensated?
No, but there's correspondence to that effect that it wasn't in the record. But
It is not in the record.
No, it's not in the record, but there is correspondence to that effect. Yeah.
Is there anything in the record, whether in the form of your affidavit or otherwise, that talks about your agreement with the defendant about how you would be compensated? I know there is compensation in connection with the first case, the individual matter. I saw that in the record. Is there anything about the purported class action matter and compensation?
I don't think so.
Okay. What does the record tell us about the duration of your business relationship with the defendant?
Tells you it lasted from about 16 months, from July of 2020 to November of 2021.
And that includes both the individual case and the purported
And the
class action?
actions. Mhm.
I take it you would agree with me, or maybe not, that the record reflects that you were the one who had the idea for the class action lawsuit?
I did.
And that you were the one who found the plaintiffs for that lawsuit?
I did.
And you brought both the plaintiffs and the idea to the defendant law firm in Georgia?
I did.
And why was it that the case had to be filed, in your view, in Georgia?
Because under ERISA, which was, the NINA had the ERISA, they specified the location was in Atlanta. The case had to be brought in Atlanta.
So What's your, well, let me back up. You're not claiming general jurisdiction, right? This is just focused on...
This is specific.
Specific, okay.
Yes, transactional.
Right. And you say the judge applied the wrong standard, that the judge applied substantial rather than minimum contacts. Where in the order are you seeing that? What language are you pointing to?
Let me just, I'll quote him directly. I don't have the reference for it, but he said, I thought I had that right here, but I can give you that. But he basically said that specific jurisdiction requires substantial contacts, not minimum. I corrected him, he disregarded it.
So
That's in the transcript. And in my brief is a reference to that transcript.
well, he definitely says you reached into Georgia to create a substantial and continuing relationship. Is that the language you mean?
No, no.
All right, but in terms of the initiation of this relationship, you reached into Georgia, is that right?
I did.
Okay.
I reached into, yes, I reached into Georgia. But I don't think that's a fair reading of Burger King. When they entered into the contract, I mean, certainly the people who were franchised in Burger King reached into Florida, the franchise. It's the contractual relationship, and both Burger King and Good Hope say that it doesn't make any difference where the contract is formed or how it's formed.
I think that...
The fact is that they reached in for consulting services from me, and our contacts relative to that are the contacts to be considered.
I think the concern, and this is not an indication one way or the other of how we'll rule, is that you could have been in any state, that your position was happenstance, but that the action here was in Georgia, that any work you did was going to be used in Georgia, and that attorneys, you know, they're not licensed here in Massachusetts, I'm presuming.
No, but they tried to represent their company here. Did you notice that?
Yeah, that was all after the fact, and the issue is what are their contacts with the forum, not even just their contacts with you. According to the case law, it needs to be their contacts with the forum. So what's your best summary, in terms of, like in a lot of these cases, we have this course of dealing where they show, oh, there were, 14 phone calls, and some of these cases were written before there was email. There were, 30 letters. So in this record that we have in front of us, what's the best statement of the defendant's contacts? It's 16 months, I get that.
Well, the first is that there's a contract.
An oral contract.
An oral
Yep.
contract is a contract. And that is made, and no one disputes that. Mm-hmm. Nobody said that there wasn't. There is a contract, and that is a contact. And there's an interesting case, Norwalk versus Takao, that's worth looking at, because it discusses the but-for relationship. And it is a tort claim, but in this case, it discusses contracts. And there's a close nexus between a contract and the damages, because a breach of contract results in a nexus between the two. Without the contract, you don't have the breach. So that's the key to transactional businesses. And that's the relationship, that's what differentiates between general jurisdiction and specific jurisdiction.
I don't see a citation to that case in your brief. Do you have, or it's not in the table of cases and authorities, assuming it starts with the word Norwalk? Do you have
I can give you,
site?
I can give you a citation for,
Oh, NOAC, is that right?
NOAC.
Sorry, a First Circuit case.
Yes,
Okay,
it's a
it
First
is
Circuit.
here, thank you.
It's a First Circuit case, and it deals extensively with the but-for proximal cause relationship. And what's important about that case is the entire circuit reviewed that result. So they must have thought it was important. It had to deal with a Hong Kong hotel being sued for wrongful death by Massachusetts, and they upheld jurisdiction. So that's the first aspect. Then, if you look in my complaint on paragraph 26, there are multiple conversations between me and them relative to these cases. And in Massachusetts Law School versus American Bar Association says the transmission of facts or information into Massachusetts via telephone, mail, or email constitute evidence of jurisdictional contact directed into the forum state. I don't know what more you can ask for. Both of those aspects. Burger King is basically, and McGee is very important. It says that a contract, once you establish this contract, and both say it doesn't make any difference who or how the contract got formed. The existence of a contract. And Burger King says that purposeful availment is proven by the form of a contract.
Well, Florida's long-arm statute seems to be a little broader than our long-arm statute, because ours doesn't, their statute says a contract, and our statute just says doing business. It doesn't have that as broad a language.
Well, but the interpretation has been that in Good Hope is that it's a very broad evaluation for transacting business. For example, in Good Hope, they say communications versus phone or mail, receiving money via check from a Massachusetts bank, that constitutes transacting business.
All right, I think we have one more question, and we'll have to leave it there.
Yes, so you're relying on the existence of the contract, and his findings, the judge termed or found a solicitation. I don't think he found a contract. Are you saying that was error for him to not find the contract existed? And upon what should he have found that? Upon your complaint?
I think it says that I had a breach of contract. Those are the counts.
Your complaint, right.
Yeah.
Other than your complaint, there was nothing for him to find there was an existing contract.
No, but I didn't realize that he had not found that there was a contract, or I would have argued that. If he said a solicitation, I don't think it's just a solicitation. I think it was a contract, because there was a agreement of how we were going to be paid, how we were going to split the costs, those kinds of things.
Very good.
There was definitely agreement.
Thank you, sir.
And no one's disputed that.
Good morning, Your Honors. May it please the Court. On the jurisdictional end, since that was the last thing you were talking about, I think one of the issues here is that the plaintiff is conflating minimum with minimal. And the in the record, and I'm going to use the page sites that say page with a number because there's a different number on the bottom.
I don't know which ones those are, but if you want us to follow along, it's helpful to have the PDF page numbers for the record appendix, because that's what we can quickly get to.
Right, and I believe the ones that say page are the PDF numbers, because that's what I used in my brief. So it would be page 145. And in there, which is also page 10 of the transcript of the hearing, the court says, and so for a specific jurisdiction, there has to be substantial contact with the forum state. Would you agree with that? Mr. Sarvis, I think it's minimal contact. And I think minimal contact is a different animal than minimum contacts that we've learned from International Shoe and onward. With those cases, as this court knows, you have to have a set of minimum contacts to be able to hail someone into the jurisdiction. And they're not here. Again, going back one page, so it would be one.
I'm actually going to pause you because one thing that's confusing to us is we have a frame for how we deal with jurisdiction cases, and the plaintiff makes this prima facie case, and you're not disputing any of the facts that he's alleging, is that right?
Well, I believe in a 12B motion, you take the facts that appear in the complaint.
Well, normally you do, but it turns out there's this whole process, and you can even do discovery just on jurisdiction, and so he brings forth a prima facie case. If you disagree, the judge can actually make factual findings, but it seems like here, we just have we have some facts that are not disputed. I just want to...
They were not contested.
So your client, for example, is not contesting that there was an oral contract?
That's correct.
And the record seems limited to me about that there was some contact. I think you'd have to concede that. There does seem to be some
Yes.
email. But we, in some of these cases, you have a rich set of facts where there's like 16 phone calls and 14 letters, and we don't seem to have that. We have like 2 emails on the record.
And that's part of what the judge found down below, that the plaintiff did not bring sufficient facts forward to the court to find personal jurisdiction, because he, being the plaintiff, has the burden to prove jurisdiction. And in this case, the center of the universe, if you will, on this is Georgia. There was an employee out of Vermont, company also in Vermont moves to Georgia. A Georgia attorney is hired, that's Attorney Bassett. Her firm, Pridgeon Bassett Law, brings a claim both in Georgia State Court, Georgia Federal Court, does the litigation down there, withdraws from the case, and the case is over. Plaintiff's involvement is soliciting Attorney Bassett and the firm, and doing some emails and such where he did some research. And especially these days, it could be anywhere. He could be sitting in Nantucket doing it. He could be, as the judge said, out in Hawaii. I believe the judge asked, well, if you were in Hawaii, could you bring her into Hawaii State Court? Yes, I could. And I think it's because of misreading of Burger King and the thought of minimal contacts rather than minimum contacts.
I don't know. It seems to me that Mr. Service has a pretty good grip on the relevant case law, and that the question, as you said moments ago, that is posed in each of these cases by International Shoe and its progeny is whether the minimum contacts are sufficient that the defendant should reasonably expect to be hailed into court. So here we have a case where it is true that the initial contact was from Massachusetts to Georgia and not the obverse, but I don't see anything, and please correct me if you do, in the case law that requires, as part of the minimum contacts analysis, that the defendant be the one who initially reached out to the other jurisdiction. And then a course of conduct that goes on for well over a year in which whatever the actual legal nature, it's sort of a consulting relationship between your client in Georgia and Mr. Service here in Massachusetts, in which they are undisputedly working together. Mr. Service is undisputably spending time and effort to create documents that are unquestionably valuable to the pursuit of the litigation in Georgia. Why isn't that enough?
Well, again, Your Honor, it's the plaintiff's burden, and I would point you to, starting on the record, page 141, which is page 6 of the transcript, where the judge pointedly asked Mr. Sarvis, what are the contacts? What did you do for a connection between Massachusetts and Georgia? And it was the connection to Massachusetts is that I did work in Massachusetts and that I sent to Bassett, who then filed that work. I live in Massachusetts, I did work in Massachusetts, and it, meaning his complaint, talks throughout about emails.
Right, so we know from the case law that what he did isn't necessarily considered at all. The question is, what did the defendant do? And that's what we're trying to understand, is what is the record as to what the defendant did?
Well, there's nothing really in the record of what the defendant did other than when she received different paperwork from Mr. SARVIS, used it in litigation in Georgia. If you look, and I know this is under the long-arm statute, this is under 3B rather than 3A, 3B being breach of warranty, but the SJC said, we construe the phrase, quote, in this Commonwealth, end quote, as referring to the place where the services or things are to be supplied rather than referring to the place of the contracting. And the services and things to be supplied were in Georgia.
Right, but she knew the work he was going to be doing was here, and she welcomed that work, right?
Yes, Your Honor. But if you look at my brief, and this is why I went into some extent to the TomTom case, and excuse me just for a second.
Right, that's the case where they hired attorneys here, but to do litigation in Texas.
Right. And so they talked about a three-pronged test to show personal jurisdiction. And in the TomTom case, there was no jurisdiction found, and they talk about the lack of contacts that the defendant had with Massachusetts. Part of the three-pronged test is the defendant purposely directed its activities at residents of the forum. It's not just the contact with this one plaintiff, it's a contact with the Commonwealth that invokes personal jurisdiction. There are no contacts with the Commonwealth. There's nothing in the record that shows that either of these the personal defendant, rather than the LLC, ever even entered Massachusetts physically. There's no advertising. She's not soliciting business
Right,
in
but why
Massachusetts.
isn't this like McGee, the insurance, I think they took over another company's book, and they inherited this insurance policy in California. They had nothing in California. They didn't go there, they didn't sell any policies there, but they had this one policy holder in California, and the court there said, that's enough. They took payment from this person, and that was sufficient to hail the insurance company into California. Why is this case different?
Well, because on an insurance policy, you're insuring a location within California or a person within California with an ongoing risk during the policy period, which I think has a lot more contact. And also, it was sold to that person with a California connection before the company was sold. So it would be unfair to have that plaintiff, that insured, should they have to bring a claim against the insurance company, to have to go into another state. And it's also, I believe it was I think it was a homeowner's policy. It's almost like a quasi-in rem type
I
of
don't know, he
jurisdiction.
died and the insurance company was saying, I think it was life insurance, because they were saying he killed himself.
Right. But that's insuring him, and that would have been for a protracted period. If it's unlike a homeowner's, it's year to year, and all right, we finish out the year and we're going to cancel you. This goes on for a period of years up to the death of the person or until the policy lapses, which is sort of what Burger King was talking about when those two Michigan residents signed with Burger King, who's in Florida. They signed an ongoing long-term contract that indebted those Michigan residents to over $1 million towards Burger King, and also set up a set of rules and regulations. They were having the Burger King name on their restaurant in Michigan. They had to abide by Burger King rules.
So I'm going to pause you there. So what was the state of the record about payments between these folks? Because it seems like he's saying that the record established that he paid them some money.
I think the record said that he had some agreement that they would split costs or something, but he also talks about and I'll find it, it's also in there, that, I think it's on page 10, that he had,
Of what?
yes, so which would be page 145. I think it's 10, oh, no, I'm sorry, that was the minimal contact. But there's one in there where he talks about this is almost, he talks about it as a contingent contract. That is, he
Who is
wouldn't.
the he? Are you referring to Mr. Sarvis or the
Yes,
judge?
Mr. Sarvis had a contract that was, or an arrangement that was contingent, where they would split costs and things such as that. I think there was something in the record somewhere where he billed, or he said he got paid some money, but I think that was towards the individual client. I don't think there's any record of my client paying anything to Mr. Sarvis.
He says in on page 13 of his brief, paragraph 18, he says that he wired from his Massachusetts bank 3 wires totaling $10,098.22. Is that, I take it that's not disputed?
It's not in the record anywhere that I saw, Your Honor. I mean, it might be listed somewhere in the supplemental 125-page.
I think he's saying it's in his affidavit, but okay.
I think the contingent, is this what you're talking about at the bottom of page 138 onto 139 in the appendix? The court, I guess the top of 139, the court asks Mr. Sarvis, what do you mean it was going to be a contingent relationship?
Right, and so he said something just prior to that, no, it wasn't written, the contract was verbal, and then, yes, it was a contingent relationship, and there was somewhere else where he had said something to the effect of they were going to split costs or something along that line. But if you look on page 141, the court pointedly asked Mr. Sarvis, you know, what are the connections to Massachusetts? And, you know, he says, well, that's where I was, that's where I did work, that's where I sent emails from. And to think that Justice then says, well, you can hail in an LLC and a person from Georgia all the way up to Nantucket, as beautiful as Nantucket is, to, you know, face the facts in a courtroom, just doesn't strike me as something that is fair.
I mean, you know, I've arrayed the cases literally in a table where somebody found jurisdiction and didn't find jurisdiction, and this case seems to be somewhere in the middle. What's the best case you think for your client?
Well, the best case, Your Honor, is that they were solicited, they needed to end the litigation, and the contact, although it might have been 16 months, was fairly minimal. We don't know how many pieces, the record doesn't show how many pieces of.
I think Justice Henry is asking a much more literal question. What case, if you had to point to, this is the best court decision?
It's, okay, because it's not Burger King.
No. Burger King, I brought that up because Mr. Sarvis relies on it heavily. And so I wanted to contrast it a bit with what was going on here. And that was going to be, I think, a 20-year relationship. And payments, there were payments made from Michigan to Miami. They went into default, so they owed the Miami corporation, on and on. There's no question there would be jurisdiction on that.
Why shouldn't we remand this for some findings on how many contacts there were and who was initiating them?
Because the plaintiff failed to meet his burden.
Okay.
You raised, it wouldn't be fair to bring clients here, but there's another way of looking at kind of fundamental fairness here as what was fair to Mr. Sarvis. Have there been any discussions, you know, between the parties?
No, not since I've been in on the case, Judge. I've spoken to him a little bit, but.
It doesn't impact our thinking at all. I was just curious.
Yes. Well, if you're going where I think there was a slight discussion.
Your position is any relief that he would seek, he would need to go to Georgia?
Yes, Your Honor.
All right, thank you very much. I think it was well argued. We understand your position and the case is submitted. We're going to take a short mid-morning break, which generally tends to be between 10 and 20 minutes.
Thank you, Your Honor.
Court, all rise. Court is open. Please be seated.
We're back, and we have two cases on for the rest of the morning, with another case continued to another day. We have case 4, number 2023-P1139, Leon Walker Jr. versus Gamal Walker and another. And I believe we're going to start with Attorney Bidak. Did I get that right?
It's BDAC, but I
Bidak.
assure you
had
I've
like
been
a
called worse
50-50
things.
chance. Yeah, sorry about that.
I have been called worse things, Your Honor. Good
Okay.
morning, you may please the court. Your Honor, my name's Frank BDAC. I represent the appellant and the former defendant in this action. Your Honors, my client believes that this case was erroneously decided for a number of reasons. The biggest being the tax returns. The tax returns in
All
this
right,
company.
could you just pull your thing a little, your microphone a little closer? Thank you.
Thank you, Your Honor. Sorry about that. The biggest being the tax returns. The tax returns have all been filed under the pains and penalties of perjury, signed by the appellee, using the appellee's own selected CPA. Now, the appellee might argue differently, but the fact is, under the pains and penalties of perjury means something in this country. These tax returns have all been filed under that. Now, the appellee's brief will say that there was no income in this company until the sale of a property. The fact is, that's not correct. If you look at the 2018 tax returns, filed again under the pains and penalties of perjury by the appellee using his own accountant, you'll see that there was a $2,400 income. That $2,400 income was divided equally. $1,200 to the appellee, $1,200 to the appellant. Fact.
So
Now,
obviously, we agree that having things signed under the pains and penalties of perjury means something, but in this case, the judge had a whole picture of evidence in front of the judge. So why are the tax returns, you seem to be arguing essentially that as a matter of law, he had to find, or she, I don't remember, had to find that there was a 50-50 partnership.
sure, I think that's a great question, and I think the reason for that is first of all, in the statute defines tax records under the LLC Act 156C. Tax records are part of the records of the corporation. Section 20 of that states that the business records of an LLC determine, except for operating agreement, when there's not an operating agreement, you look towards the business records. Those business records clearly represent 50-50. Another important fact, if I may, along those lines, without respectfully beating myself up too much, it's the parole evidence rule. The parole evidence rule is not waived, even though that testament, all the evidence came in. The fact is, Mears versus Smyth, 199 Mass 319 on page 322 states that, and it's an SJC case. It's cited in the brief. The parole evidence rule is substantive law. The parole evidence rule says that information in a writing that is not unambiguous, all testimony should not be permitted to come in. So in reality, if there's ever a document that should be able to stand on its own, it's a document or documents that are under the pains and penalties of perjury. Now, it's not just the 2018 tax reports that are important, but most importantly, the 2020, which is about a year after the sale of the property. Now, that, if you look at the appellee's brief, the appellee will argue and states that that was after a number of communications between the parties talking about money, distributions, and ownership. Even after that, the appellee filed their tax returns for the company under the pains and penalties of perjury, 50-50. Now, the problem with this decision is that if it stands, what that stands for is that the tax returns of a company, the W-2s, the K-1s, what does it mean? If I may, I'm sure in your careers, you've received W-2s, you've received K-1s, and you've relied on them. That's what this defendant did in filing his taxes after the sale of the property. And what it got him was a judgment of fraud and conversion.
Well,
Now,
I mean, this case, I just want to be clear about what the plaintiff is asking for here and received. There is a multi-count complaint that alleges that your client breached a fiduciary duty and needed to provide an accounting, and committed fraud and conversion and a couple of other claims having to do with a $100,000 payment that was made by, I'm just going to call them the father and the son, by the father to the son, and another $60,000 payment by the father to the son, which I think the testimony is that some amount of it, maybe $29,000, was actually repaid. The question of the ownership of the LLC is relevant to one issue in my reading, which is to your client's defense that that $100,000 was actually a share of his share of the proceeds from the sale of the property in Dorchester. Is that right?
that is correct, Your Honor.
So this was tried to a judge, not a jury, by agreement of the parties? Is that right?
That is correct, Your Honor.
And there was witness testimony, and the judge made special findings by agreement of the parties?
That is correct, Your Honor.
So I guess what I'm struggling with is our standard of review is that we give deference to the fact finder's findings of fact. And in this case, one of those findings is that this was a theft of money, that the $100,000 was intended by the father to be invested by the son for the benefit of the father, which by its terms excludes the possibility that the $100,000 was intended by the father to be a payment to the son for his share of the Dorchester property. How do you get us around that standard of review to a point where we can reassess the evidence and reach the conclusion that you would prefer?
Sure, thank you, Your Honor. I don't think it requires that. I think the statute's very clear.
Which statute?
MGL Chapter 156C, LLC Act, Section 9A3 talks about tax returns. 9B talks about what is a record. A record by law, by statute, is the tax returns of the LLC. That is the statute. That is not something, in my view, Your Honor, this decision is actually writing law. The statute clearly says what it says. That is a business record. It's clear, it's unambiguous. The tax returns are clear and unambiguous. I know that because it's signed under the pains and penalties of perjury. The other thing that's very, very strange about this case, Your Honors, is that there's a letter that's in the brief and in the record that talks about, from plaintiff's counsel, July 27, 2021, after the sale of the property, where plaintiff's counsel states to the then pro se defendant, this letter is written to you in your capacity as manager and member. That's how you get around it. An attorney, this decision right now stands for the cheapening, for lack of a better way of saying it, of the standard of pains and penalties of perjury, stands for the cheapening of someone relying on a company's tax returns to file their own personal tax returns. And then, I tried this case with this gentleman. I know Attorney Kindergren is extremely ethical, very straightforward. He was a joy to try this case with. But that decision would say that my client's not a member, which means,
Well,
if I look
I'm
at
not sure
MPRE,
that's-
if I may, Your Honor, MPRE 4.1, that's a misrepresentation of a material fact to a pro se defendant. That's what this case will stand for.
I don't think that being a member is the same as having a 50% ownership interest, right?
Well, being a
Original question. It seems like you've gotten to the point where your answer is that we should determine on these facts that the trial judge made a clearly erroneous factual determination based on the record.
That is correct, Your Honor.
So what contributions did the son make to the LLC? Right, in other words, the father donated the property or contributed the property to the LLC and at least for many years paid taxes and filing fees. What did the son contribute?
Well, that's in the record. It's not in the appellee's brief, but it's in the record. The plaintiff admitted that, the appellee admitted that the appellant paid $3,300, so the property would not be foreclosed upon. The appellant would say that was $5,000, but that's an initial part of the proceeds, if you will, of what the appellant paid in. Obviously, he spent time trying to get an architect in, again, in the record, and assisted the plaintiff in numerous other ways, or the appellee in numerous other ways. That's in the record over that time.
So the father argues that your argument is contrary to a case called Beninati.
Sure.
What do you say? Why is that case different?
It's a fantastic case that's completely unlike ours. First of all, our case was 1 day. We have 3 categories of documentation: tax returns, the aforementioned letter from the attorney calling my client a member, and then bank statements filed before and after the sale of the property, where the plaintiff himself from Bank of America, this is in the record, states that he was involved in a partnership. Who was he in a partnership with? He was in a partnership with the appellant. All in the record, all unambiguous, all according to the mayor's case, the SJC case 1908. That evidence should not, the oral testimony should not be permitted to refute that. That is the SJC. That to this day is the Commonwealth law as I understand it and as I shepherdized it. And the other thing I would say, I'm looking at the time, is if the trial judge was correct and the plaintiff was 100% owner, why is there a need for an accounting? $160,000 went to the defendant, $160,000 goes back to the plaintiff. Very simple. My client should never got 1 penny. But the accountant says, well, we're going to, or the accounting would say, well, we're going to take money that, we're going to consider money that you paid in your taxes as not going back to the plaintiff or the appellee. That makes no sense. You are either 100% owner or you're not. The fact is the accounting is, actually evidence is why this is in a clearly erroneous case. And I would suggest it also, asking for the accounting, I would suggest to the court that's exactly what the plaintiff knew, because the plaintiff's own attorney knew in that letter that the defendant was an owner, was a member. That's why they asked for the accountant. So I don't know.
They asked for the accounting because, according to the complaint, the father provided $100,000 that was allegedly invested, and then $60,000 to pay tax obligations, of which $29,000 had been returned. And the request in the complaint was for the son to make a full and complete accounting of all funds taken, as well as provide full disclosure of actions and alleged investments.
That's obviously a factual issue that the evidence would suggest differently. Again, that's all assuming that the writings in this case are to be not followed. You know, the parole evidence rule just simply says that's not the case. It's just, and that's SJC, that's just not the case. That oral testimony that came in the trial, mea culpa, by substantive law, should not be heard. And this case, if it stands, and I will say again, with the accounting, if someone is a 0% owner of a company, the asking for an accounting doesn't make sense on its face, because return all the money, return $160,000.
What if he had invested the $160,000 in some fabulous investment and made, I don't know, a 12% rate of return? Wouldn't the father have been entitled to know that and to get the interest on his own money?
Well, I guess that's the issue. Is it his money? The appellant clearly, and it's supporting, my client's position is clearly supported in the record by those tax returns, in particular, by the admission from the plaintiff's own, the appellee's own attorney, that he was an owner. So the fact is, if that was the case, maybe, but, but that's just not the case. The law is very, very clear on this, and it's SJC law, and I would suggest that it's cited in this brief, and I don't think the mayor's case was refuted at all in the appellee's brief, and there's a reason for that, I would suggest, Your Honor, because it's the law in the Commonwealth of Massachusetts. So I'm looking at my time. I thank you for your time. I'm obviously here. You control the microphone, not I. Thank you.
Good morning. Let me just back up here because I think the critical issue at the outset is the standard of review. It makes a big difference in terms of what this court does. This case was tried under Superior Court Rule 20, and Rule 20 effectively, when it came into effect a few years back, gave us the ability to have a judge not have to make detailed findings of fact and conclusions of law, but rather we can hand the judge a set of questions that the lawyers agree on, as we did in this case, and say, please answer these questions for us, just like a jury verdict. That's what this case was tried upon. So in this instance, we gave the judge those questions, and the judge made the findings that are in the record.
So, but he says, well, there's this letter, there are bank statements, and there are tax returns. Why, and the judge should not be able to disregard all of that, not only the documents, but really a course of behavior. So why is he wrong about that?
Well, he's wrong for several reasons. Number one, it's been addressed by this court, meaning the appeals court, before. Let's take, for example, the tax returns. In the Beninati case, which Justice Hershfang referred to, there was a decision by Judge Sanders at the trial court level. It came up to the appeals court, and she had found that the ownership interests in that LLC, this was a bunch of different health clubs in that case. They all had separate LLCs, and they were all fighting about who owned what. And she made decisions about the ownership interests in those LLCs that differed from the tax returns. And she looked at all of the evidence. And the two things that this court established on that point, there were a lot of issues in that case, but on that point were that a trial judge who is confronted with figuring out ownership of an LLC should look at all of the evidence and make a decision, factual decision about who owns what. Factual decision. This is in the, by the way, just so I'm clear, this is in the absence of a written operating agreement. Every LLC should have an operating agreement that tells you who owns what. But unfortunately, in real life, that doesn't always happen. It didn't happen in Beninati, and it didn't happen in this case. There's no operating agreement. There's nothing that stipulates as to the ownership interest.
Right, but so why should we let people just disregard all these tax returns that they filed? I mean, his argument is, well, that just makes the signing under pains and penalties of perjury meaningless, and that's bad.
Okay. Well, again, this court said that looking at the tax returns was maybe some of the evidence, but it's not all of the evidence, and the court should look at all of the evidence in making ownership decisions. So that's the law as I see it.
Is he, by the way, correct in characterizing the record that there are several tax returns that indicate a 50-50 ownership of the LLC?
Yes. Yes. So here's the thing. The evidence in this case showed that, let me back up. Leon Walker who's now 84 years old, bought this piece of property in 1979. Now, Leon spent his life working as a taxi driver, and then he got a job in a hospital moving medical records around, okay? He's not an educated man. He bought a piece of property in 1979. His lifelong goal was to do something with it. He never acted on it. So he finishes out his career in 2000, around that time period when LLCs were coming into existence. Somebody told him, put your property in an LLC, and he did it. He created an LLC, he moved his property into it, and he, in a couple of the annual filings, said that he and his son were the managers of the LLC. Now, there was an operating agreement for that first LLC, and it refers to him as a member. So presumably he was the only owner. That LLC got dissolved because he didn't pay his bills to the Secretary of State.
The theme of today, yes.
So then he created a second LLC, and once again, he and his son are identified as the managers. Now, a manager does not have to have any ownership interest under our statutes, okay? But there's no operating agreement for that second LLC, and so Leon considers that to be his property still. I mean, he's the only one that contributed anything of substance to the LLC, which means the real estate.
Well, just to pause you for a minute, though, the son says, well, whether it was $3,300 or $5,000, he contributed money to prevent foreclosure.
He does. He says that, yes. Leon says it was a smaller amount of money and it was a loan, and I will say this, Your Honor, if you were to look in the record appendix at page 301 to 304, that's the bank statements that what happens after the sale of this property. You will see, and I think this is spelled out in our brief, but you will see payments that Leon Walker made to his 3 children, Lisa, Gamal, and Kimberly. And he wanted to repay them for everything that each of them did for him. For example, they spent time and money cleaning up the property for him, and they had some cars towed that he had on the property, all this stuff. He wanted to reimburse them, and that's the first thing that you see in the disbursements. After $289,000 comes into his account, he makes payments to the 3 children for their expenses. There's a separate line item for Gamal. Gamal got paid for some his contributions along with the other 2, but he also got a separate payment of $8,000. And that was meant to be the $5,000 that Gamal claimed he put in. It was returned to him there, plus $3,000 that Gamal said he spent on getting a plot plan drawn up, or a picture of the property. Leon reimbursed those amounts to him. Now, that's not, wouldn't reimburse him for those payments if he was an owner contributing equity into an LLC. But he accepted the $8,000, he accepted the other reimbursement of his, and those, I think, take care of all of the things that he has claimed. And again, I think this case really turns on this issue about the tax returns, right? That seems to be the primary argument. But the standard, at least as established by this court in Beninati, is those are some evidence, but they are not binding in terms of ownership interest. And so I think when Judge Sullivan looked at all of the evidence in this case and the history and the contributions and the reimbursements that each of the children received, she concluded that this was, in fact, Leon Walker's property. This was his thing. He had it for his whole life, and he wanted to develop this property.
But when a judge issues a ruling like that and knows there's this history of tax returns, should it be contingent on saying, but go fix your taxes and pay what you need to pay?
Well, that's effectively what they did. I mean, my client, before this lawsuit, recognized that there was these errors in the tax returns, which he had seen. He took them and stuck them in a file. He didn't, again, he wasn't going into this stuff in detail because it didn't really matter. He said he figured, between him and his son, they knew whose property it was. So this comes up around the time that the property sold. And at that point, he recognized, because of it, that there'd be some tax implication to his son. That's why he sent him the $60,000. Gamal said to him, I'm going to have a tax responsibility. Leon said, I'll cover that cost. If you get stuck in this because of my, the tax issue. So he sends him $60,000. He says, but as soon as you pay your taxes, send back everything you don't use. And that was the agreement. In fact, there's a text message that happens the day as soon as Gamal tells him I filed my taxes, Leon sends a text message to him and says, how much are you sending back to me? Because that was their deal. That's in the record. And so he covered that expense for his son, so he wouldn't have any adverse tax consequence. And he didn't have an adverse tax consequence because he got paid for it. By the way, as far as the accounting, the point was, what he didn't do is say, here's the documents showing exactly what I did have as a tax payment, right? He just said, I'll send you $29,000, or he said 30, I'll send you 30,000, but he spent 29. So one of the things I think Judge Sullivan wanted was an accounting of what did you exactly pay in taxes, Gamal, tell us, and then if it's a smaller number, you still owe some more money back to Leon. That's what the accounting is all about in this case. So I think, I know I started off with the standard of review because I think once you have a judge who looks at all of the evidence and considers all of these issues, by the way, it's not like these are being raised for the first time in appeal, right? This was all argued. All of those documents went to the trial judge. She looked at all the evidence. She listened to the witness's testimony. She learned about the history of it. All of the, there's 30 some odd exhibits that went into evidence in the case, and 3 witnesses testified. And she made a decision based on all of the facts that was the circumstance that you had, that this property belonged to Leon Walker, who had bought the property and put it into the LLC in the first place. And that decision, I think, can't be reversed unless there's an error of law. And I think the only error of law that's suggested is that somehow the tax returns are absolutely 100% binding, and that just flies in the face of what the Benenati case said. And I don't see any reason to change that, because sometimes parties will fail to make an operating agreement, fail to spell out who owns what, and somebody has to make that decision down the road. Trial judges do that, and that's what they do. And that's what happened in this case. And it's completely justified on the evidence that was presented. I think one other point, and it just supports that, is that there are statutes that deal with situations where there's either a dispute or a lack of information in terms of what parties get when an LLC is closing down. And those all seem to be based on, well, look at who put what into the LLC, right? Who contributed what to the LLC? This is in 156C. There's different statutory provisions. And that's effectively what happened here, because, again, Leon put this property in. GAMAL really didn't put anything in except that small amount of money for which he was repaid and reimbursed at the time of the sale. So, if there are any other specific questions, I'd be happy to answer them. I can certainly talk about the case for quite a while.
If you've made your points, then that's fine.
Okay.
One of my colleagues used to say, if you've run the bases, you don't need to run them twice.
Fair enough. Thank you.
Thank you. That case is submitted. I think we understand your arguments. Our last case today is 2023 P0644, FARIA J. Simmons versus Nicole M. Chase. Or FARIA. And I think we're hearing first from Attorney El Mano. Please correct
perfect.
me. Oh, well,
That was perfect.
my week in Spain did something good.
Well, may it please the court, Lawrence Almagno, I represent Ms. Simmons. This is an appeal from a jury verdict based upon a PIP issue, PIP being reduced prior to the prejudgment interest being applied. And the issue that the plaintiff has is with the jury instruction and the verdict slip. The combination of those created the error that needs to be reversed by this court. The jury was presented with a verdict slip that says damage.
Let me ask you about the instruction and the slip before
Yes.
we hear about them. There was no objection to them at the trial. During the conversation about the instruction, you mentioned that you had you proffered instruction, but the judge rejected that, and the judge talked to the parties and gave her own instruction. There was no objection. And then after the instruction, the judge asked the parties if there were an objection, and the parties stated no. You stated no.
That is correct, and that was based upon my assumption that the verdict slip dividing up pain and suffering and medical bills would have been the one used, and that wasn't the case. It was the special verdict slip that just talked for about the total amount of damages. And I wouldn't have a problem with it, and I wouldn't have a problem with PIP being reduced, except for the fact that the jury got the medical bills that already said it was paid for by insurance, and that had a balance of $600. So my opinion is that the jury already calculated that. They already made that reduction. They saw that, and they awarded on pain and suffering.
But how do you know they did that?
That's why we're here. We don't know, and that's why this court can't do anything but reverse it, because we can't look into what the jury was thinking. We can only see what the jury did.
Well, is it correct that the parties stipulated that the plaintiff incurred a specific amount of damages, $4,101.14 in medical bills?
That is correct. And we also stipulated that there would be no mention of insurance. However, that's not what happened.
Right,
At
but he
trial-
says that was on you, that you didn't object to the medical bills as they were sent to the jury and nobody redacted them. Like, if you had asked, they could have been redacted to take out the PIP part.
If we redacted them, there would be nothing for the jury to review in terms of the bills. It would have been in effect reducing any money in there, the practical effect. If you look at that
Where's
bill-
the bill in here in the record?
It's in the appendix, it's from National Physical Therapy, and then it's on the PDF. I wish this told me the page number. 42, thank you. And if we look at that, you see pro medical, 1,100 is $1 is the balance, and then National Physical Therapy states amount 2,400, balance due $600. So that was, and then if you go to that next page, it shows insurance payments. So the jury, because of the fact that they didn't have a verdict slip that said medical bills, medical expenses, and pain and suffering, they looked at these bills and they gave an award based upon this reduced amount. To then have it reduced again is giving the insurance company another windfall. They awarded on pain and suffering, and I think that's clear by the instruction that the judge provided. Go add up these medical bills, then add to that pain and suffering, and then that's your award.
So, but I don't understand, why could you have just not submitted page 44? So then nobody would, they wouldn't know who paid the money, they would just know the total charge.
I mean, I believe that the jury already knows that PIP exists. We have a Massachusetts jury, many of them from the voir dire have been involved in car accidents before. I think to assume the jury doesn't know how PIP works is to discount our jury system. They're intelligent people with lived experiences. And many of them, upon voir dire, admitted to being in car accidents before and admitted that insurance took care of it. So to pretend that they don't know that when they're in that box, I think is silly on our part. And I believe that the jury awarded pain and suffering money. They put that $1,000 in there that was owed to Sturdy from Pro Medical, and I think the rest of the award was pain and suffering. And the fact is, they didn't have a slip to decipher it, so I think...
Well, but I mean, I want to go back to that. So I pulled up the portion of the transcript where the parties are talking with the judge about the slip, and it's in the supplemental appendix on page 4. And the judge says, the special verdict slip I'm kind of proposing here would be what amount of money would fairly and adequately compensate the plaintiff for any injury she suffered as a result of the, and then there's some discussion about the date. And there's no objection. So how, based on that, did you understand that the verdict slip was going to break out the categories?
I was fine with that at that point. The problem arises once the judge reduces the PIP prior to the interest being calculated. That's where this all arose. At that point in time, I was fine with that verdict slip. Not my preferred verdict slip, but I was fine with it. It's the way that the reduction was done after the jury came back. The jury came back, they awarded for the plaintiff, and prior to the calculation of interest, that PIP was reduced. And you can see the vast difference in the award if you do that.
Of course, it's a huge difference for your client. I guess the part that I'm struggling with, and I hope you could help, is sort of a two-part inquiry. One, as a general matter, the point of prejudgment interest is to compensate a winning party for having not had the use of the money until that time, right? And with the PIP funds, however much they were, your client actually did have the use of the money for that amount of time. But I do, I understand that in Fusaro? Is that in the Judge Cass decision, I can't remember which one it is, it seems to say something very different, And that doesn't make sense to me, but maybe you can make it make sense?
So I love that question. My client didn't have the use of the funds. The medical provider did. Now, how does that benefit my client? I'm going to take the position that it doesn't benefit my client. It only benefits the medical provider. The medical provider would have provided services if they weren't paid regardless. They would have taken a lien on the case. Say this involved somebody that didn't have PIP or out-of-state policy or something that did not apply, or if it was a slip and fall that automobile insurance and PIP doesn't apply to. That medical provider would be waiting until this day to be paid.
So your client would then, I mean, doesn't that make the interest a windfall then?
To the insurer?
To your client?
No, it doesn't make it a windfall to my client when they're having that reduction done, and I'm going to save this court from doing math on the fly. I'm not good at it.
Thank you.
But my client didn't benefit from anything. My client went and got treated. The insurance provider paid the medical provider. It was a transaction between those two parties, not my client. She didn't get that money and was able to put it in a CD and earn. That's the whole point of interest. If she took that money and put it in a CD, we say 12% per year.
If you can find a CD that pays 12% per year, I would like to know about it.
I would too, but that's
Look for a time machine back to the 1980s.
Yeah, that was a decade I was born.
Don't make us feel old.
So that's our argument. Our argument is that the PIP should have never been reduced prior to the award of interest because the jury already made that decision when they awarded the jury award.
So he's arguing, though, that Chapter 90, Section 34M basically says PIP benefits are granted in lieu of damages, and so you just can't put them in this prejudgment interest category. What do you say to that?
PIP would have applied if my client was at fault. So we didn't, up until the jury came back, and yes, it was a rear-end car accident, we could assume that my client would have won, but juries do strange things. Maybe they didn't believe that she was hit that day. Who knows? But the prejudgment interest should not be reduced by that PIP that because of the fact that we don't know what the jury awarded in medical damages versus pain and suffering. And I see this as a straight pain and suffering award due to the fact that the jury was presented with medicals that were paid by insurance, except for that $1,100 sturdy memorial bill. And so
Are you saying you think the jury awarded like 5 times the medicals for pain and suffering? If it was 1,000 for let's keep the math simple. If it was 1,000 for personal injury and a $6,000 award, or?
I think that the jury doubled the medicals.
Okay.
I mean, if you look at it, it's 2,400 plus 600 so that's $3,000 plus, I think they doubled that with their award, and that was 6,100 and whatever dollars that they awarded. So I think the insurance provider already got that benefit of the jury reducing the award based upon the medicals that were paid by PIP. Thank you.
One question for you. When does the prejudgment interest in this case start? Is it the filing of the complaint?
That is correct.
Okay.
I wish it was sooner, but I wish it was the date of loss. But
Also, I had a question. You'd like to tie the prejudgment interest to the jury verdict, correct? But the statute says that any action which a verdict is rendered or a finding made or an order of judgment made. So it's not necessarily tied to the verdict, it's tied to the judgment, correct?
yes.
Another question I have is, in our research, we came across Bowman v. Plymouth Rock Assurance Corporation, 82 Mass. App. 135. In that matter, Justice Traynor the appeals court, did look at this issue of calculation of prejudgment interest on net or gross damages. And part of the calculation did include a PIP payment as well as some other medicals. This was review of an arbitration, but the court concluded that prejudgment should be on net damages. For the point that my colleague, Justice Hershfang, raised, that that's money that they didn't have, or the purpose of the prejudgment interest is so they wouldn't lose a benefit for the money they didn't have. Did you read Bowman, or are you familiar with that case? And
I did read it, and I read a number of cases, but the thing that I found quite intriguing with respect to this issue, because I don't want to speak for my brother, but I believe we both were perplexed with the case law. I think that the difference is that verdict slip, that doesn't have something pointed out for medicals and then pointed out for pain and suffering. It was just damages. And I think that's what makes this issue so complicated, albeit I'll concede to the court, it seems simple, but the more you dive into it, I don't think it really is. I think it's because of that slip saying damages and not pain and suffering and then medicals. And I think that's what created this issue. Thank you.
Thank you very much. We'll now hear from Attorney Noble.
Thank you, You're very welcome. Thank you, Your Honor. Members of the panel, may it please the court, Gregory Noble of Lynch & Lynch on behalf of the defendant, Ms. Nicole Chase. Your Honors, this is something that the district and superior courts of the Commonwealth are faced with on a daily basis. And the reason why my brother and I had such a difficult time in finding cases directly on point with this factual scenario is because it's dealt with on a daily basis. It's something that is just routinely done. When a jury returns a verdict in favor of a plaintiff in a motor vehicle accident where PIP applies, the PIP amount is deducted from that jury's verdict, and then interest is calculated by the clerk. So,
but do you agree with counsel that the verdicts are often different, or is this a one-off where there's only one category?
Questionnaire, was the defendant negligent? If so, was their negligence a substantial contributing cause to the plaintiff's injury, and what amount will fairly compensate the plaintiff? So under these circumstances where my brother is arguing that the jury misconstrued the amount of damages and there is an open question as to whether or not their award represents the medicals or pain and suffering or some combination of the two, I would submit that the stipulation between the parties that there was $4,000 or so in medicals, it was a stipulated figure that the jury was instructed on. So there's no question about what the amount of the medical damages were. And to then parse that out in a special verdict form, I would submit is unnecessary under these circumstances. Moreover, Your Honor, my brother indicated, as Your Honor pointed out already, he raised no objection to the verdict slip before it went into the jury.
Right, but why do it this way where we kind of create a mystery? I mean, particularly in this case where you've stipulated on the medical bills, why doesn't the verdict just say the parties have stipulated to medical bills of X, what's the award of pain and suffering? And then everybody's clear what happened. Why?
That's exactly what happened, though, Your Honor. The jury was instructed that the parties have stipulated to X amount of medical bills. Factor that into your award along with pain and suffering and give us a total amount.
So he thinks that the jury doubled, but you, because they took out the PIP, you're saying the jury basically gave half the medicals as...
I can't say what the jury gave or didn't, whether they factored the entire medical bills or not. That's something that goes on in the jury room, and we're not allowed to have that information. But what was told to the jury and what the stipulation of the parties was that there were $4,000 in change of medical bills, and that the jury was allowed to award compensation for pain and suffering. And the jury went out and deliberated. They had these medical bills, but I would submit under the circumstances, there was really no reason for the medicals to be in there in the first place. There was a stipulation to the amount of bills. So for us to now try and put ourselves in the mind of the jury, that's not our job at this stage. The fact of the matter is, none of this was brought to the court's attention at the trial court. The judge wasn't made aware of any collateral source argument on these medicals. There was no objection to the medical bills going in unredacted. There was no objection to the judge's instructions to the jury, and there was no objection to the special verdict slip. So under those circumstances, in fairness to the trial court, I would submit that we are here to determine errors of law, and there was nothing to flag for the trial judge that, hey, there's an issue here that we need some assistance with.
So is your position that it's discretionary, that the judge may reduce the award and then do the
No, Your
math?
Honor, it's actually statutory. It's an immunity that is afforded to the defendant. He is immune from tort damages up to the extent that those medical bills were paid by PIP. It is absolutely not discretionary. What may be subject to dispute in certain cases is the amount of those bills that were paid. But routinely, this is a stipulation between the parties because as Justice Smith mentioned before, this is, or actually, Your Honor, I believe it was you, Justice Hershfang.
We all look the same.
The funds were never to the plaintiff. So this is a circumstance in which it's an administrative statutory agreement between the insurance companies.
Right, and I guess I apologize for my indefinite antecedent in my question. When I said it was discretionary, what I meant by it was the timing is the wrong word, the process, the procedural, right, the order by which the judge was to do the math that included applying the prejudgment interest.
Yes,
So
sir.
let's say, can I ask this really stupid question? Why was this in Superior Court?
I wasn't trial counsel.
Okay.
I am not sure as to the underlying
Okay.
facts, but
Never mind.
I had the same question.
So what you have here is Judge Sanders, who's a very experienced judge, who goes about this by taking out the PIP amount and then calculating the PJI. What if instead she had left in the PIP amount and then calculated the PJI? Would, in your view, would that, the decision of the ordering of that have been within her discretion, or would she have committed an error of law if she had done it the other way around?
I would submit that that would be an error of law because at the time that the PIP reduction was done, it was not yet a judgment. It was the jury's verdict. And prejudgment interest operates on a judgment. So, and it's the responsibility of
Doesn't it operate on a finding?
It can operate on a finding, yes, Your Honor, but I would submit that it also operates on a finding of a sum certain. And so I would submit that the sum wasn't yet certain until there was the reduction of the amount of PIP. And particularly in this circumstance, the court was already aware of the existence of a PIP offset. This was a motion filed in advance of trial. So the judge was aware of this administrative issue before the jury was even in the box, frankly. So for us to then say that the judge could theoretically have reduced the PIP amount after prejudgment interest was calculated, it's just not in keeping with the process as set by the statute. Prejudgment interest is calculated by the clerk following the entry of a judgment, whereas the PIP offset is a motion that's presented to the judge following the return of a verdict. And for that point, Your Honor, I would direct the court's attention to the supplemental authorities that I filed last week. I believe it was Gendron v. Rhodes. That is a Superior Court decision, and the site there is 2002 Mass Superior Lexus 513. And that decision highlights the fact that the amount of PIP is a immunity or an exemption for the defendant, and to ascribe interest on that amount for an amount of money that he is not responsible for, it is counterintuitive to say that he is responsible for the interest, but he's immune from those damages. It just doesn't jive. So I would submit that under these circumstances, the issue that is really here is whether or not prejudgment interest should have been calculated before or after the PIP reduction. I would submit that Judge Sanders did things appropriately here. I'd ask the court to maintain the trial court's decision.
Let me ask you, counsel, my understanding, part of the rationale of PIP is to avoid many tort claims, or numerous tort claims. It's to make prompt payment of certain bills, payments that are due. Are those payments usually associated with medical?
Yes, almost exclusively associated with medical. So you can also receive them for
lost wages?
Lost wages as well, Your Honor, yes.
Let's say there was a special verdict where, in this case, or where there was a line for medical bills, and for some reason the jury disregarded the stipulation, it said 0, and then there was pain and suffering, mental or physical, and they said $5,000 or $6,000. Would it have been error for the judge to reduce the pain and suffering by the PIP?
Yes, because PIP does not apply to pain and suffering. And I would submit under those circumstances, my first move would be to file a judgment notwithstanding the verdict, because you can't just have 0 medicals on a case such as this.
Well, actually, last question. Have you read Bowman?
Your Honor, I was actually very pleased to hear Your Honor mention the case. I unfortunately have not read it, but I would, again, direct the court's attention to that Gendron v. Rhodes case, which does stand for the same proposition there.
Very good.
Thank you very much, Your Honor.
Thank you very much. That's the end of our session today. I just want to thank all of our staff, our court officers, and our clerks, and all the cases we've heard are now under submission. Thank you, counsel.
All rise.